In this video, I am going to discuss the very important questions on Bhartiya Sakshya Adhiniyam 2023. These questions I have selected from the previous university exam questions, and I think these questions are very important for your forthcoming exams, your semester exam. So let's start. Question number 1. What is admission? Who can make admission? By whom admission can be used as per Bhartiya Sakshya Adhiniyam 2023? The answer will be, according to section 15 of the Bhartiya Sakshya Adhiniyam BSA, an admission is a statement made in oral, documentary or electronic form about a relevant fact or disputed fact made by a party to the case. कहने का मतलब है कि एडमिशन या स्वीकृति क्या होती है? इट इज स्टेटमेंट मेड इन ओरल, मौखिक, डॉक्यूमेंट्री या इलेक्ट्रॉनिक फॉर्म में किसी भी फैक्ट से रिलेटेड जो कि केस हुआ है, मुकदमा दायर किया गया है उस केस में. नाउ हु कैन मेक एडमिशन? एडमिशन कौन दे सकता है, कौन कर सकता है? स्वीकृति कौन कर सकता है? तो सेक्शन 16 सेज फॉलोइंग कैन डू admission, can make admission. Number 1, any party to the proceeding, plaintiff or defendant. Second is those authorized agents whom the court considers authorized to give a statement clearly or indirectly according to the circumstances. Third is those persons who have ownership or financial interest in the subject matter of the case. It means those persons are also entitled for admission, those who have interest in that particular case. Fourth is persons from whom the parties to the suit have derived their interest. I have given example for this to understand it better. Persons from whom the parties to the suit have derived their interest. If A sold land to B, suppose A is selling his land to B and later on B sues for that land. B is sued for that land, then A is the person from whom B has acquired the interest. So this was about who can make admission. Now coming to who can use it. So answer will be, this can be used against the party that has filed the case. This means it serves as evidence and can be presented in court to prove the facts. But there are some conditions. There is important conditions. First is the acceptance must be made voluntarily. There must be no coercion or threats. Whatever acceptance is there, admission is there, that must be voluntarily. And it should not be due to threat or coercion. Acceptance itself is not conclusive proof, but it is very strong proof. So these are the important conditions for making admission. Now question 2. Question number 2 is explain fully the rule oral evidence must in all cases be direct. Are there any exception to this rule? Then the answer of this question will be, first part, under the Bhartiya Sakshya Adhiniyam 2023 under section 55 says that all oral evidence must be direct, generally meaning a witness can only testify about facts they personally perceived. A person who has personally saw, heard or felt. Hearsay is generally excluded. Hearsay evidence is not included, ensuring the evidence comes from the best available source. If it refers to the fact that could be seen, fact that could be heard, fact perceived by any other sense, an opinion or the ground for it, then the witness must prove these conditions or opinion. Oral evidence must be the, this is the answer to the second part. Oral evidence must be direct with some major exceptions as follows. So what are the exceptions? Dying declaration. Section 26A of BSA Statements made by a person regarding the circumstances of a transaction resulting from or causing his death are admissible, as the witness is no longer available to give direct testimony. So, when a person is dying and he gives some statement, then that is acceptable. Let's just say section 4. It states that fact not in issue. It states that those facts, although not in issue, that are so closely connected to a fact in issue as to form part of the same transaction are relevant, even if they occurred at different times and places. Admissions and confessions. Section 15 to 25. Statements made by a party to the suit or their agent, which can be regarded as indirect evidence of disputed facts. Now, expert opinions. It comes under section 45. If a living person is especially skilled in a field, that is for forensic expert, handwriting expert, then his opinion, their opinion is relevant. So this was the answer for question number 2. Now coming to question number 3. What is the law related to relevancy as enumerated in BSA 2023? Draw the distinction between relevancy and admissibility of evidence. So here answer is section 3 to 17 of the BSA determine which facts are relevant. Evidence must be connected to facts in issue or other relevant facts. Evidence must be connected to facts in issue or other relevant facts. So these are the conditions. Relevancy denotes the logical connection between facts. Relevancy denotes the logical connection between facts. All the facts which are produced or which are submitted, which are told, are interlinked. They are logically connected with each other. Relevancy includes facts that form part of the same transaction, occasion, cause, or effect. So this is the law related to relevancy in BSA 2023. For example, facts deemed relevant include motives, preparation, previous or subsequent conduct, and facts necessary to explain or introduce relevant facts. So this must be included: motive, preparation, previous or subsequent conduct, and facts necessary to explain or introduce relevant facts regarding that case. Now, what is the distinction between relevancy and admissibility? So, in short, we can say relevancy and admissibility are distinct concepts, relevancy being based on logic and admissibility on legal rules. I have prepared a table for you, and I am going to differentiate relevancy and admissibility. So first is logical connection of a fact to the matter in issue, that is relevancy. Admissibility, legal requirement following a fact to be presented in court. Second is logic and human experience based on sections 3 to 17. And this is law based on sections 3, 15 to 23 and 61. This is based on law. Admissibility is always based on law. Wide, all relevant facts are not necessarily admissible. In case of relevancy, narrow, all admissible facts must be relevant. In this case, all admissible facts must be relevant. Relevancy is usually determined first. First, relevancy is usually determined. Admissibility decided after a fact is deemed relevant. So, when a fact is considered relevant, then there is admissibility of that fact. A relevant fact may be excluded by law, hearsay. It may be excluded by law. But admissible evidence must pass legal hurdles. Means this must be legal. Otherwise, that fact will not be admissible. Key distinction, we can say all relevant facts are admissible, but all admissible evidence is relevant. All facts are not admissible. All relevant facts are not admissible, but all admissible evidence is relevant. For example, a confession to a police officer might be logically relevant, but it is inadmissible under the BSA. It cannot be admitted. So it is inadmissible. Now coming to question number 4. What is meant by hearsay evidence? What is the principle on which non-admissibility of such evidence is based? State the exceptions, if any. So answer will be under the BSA 2023, Bhartiya Sakshya Adhiniyam, hearsay evidence is second-hand information, where a witness testifies about a fact he did not personally perceive, but heard from someone else. It means he has not perceived himself, but heard from someone else. It is generally inadmissible, but it is not given on oath. Because it is not given on oath, cannot be tested by cross-examination and lacks reliability. So, hearsay evidence is not reliable. It lacks reliability. Principle of non-admissibility. The rule against hearsay is based on the best evidence rule. The court required that the best possible evidence, which be direct personal observation, be presented rather than indirect diluted testimony that could be a result of hearsay, rumor or fraud. Now there are some exceptions of hearsay. First is res geste, same transaction. Statements made immediately before, during or after an occurrence that are so closely connected to the event are admissible. The events which are the part of the same transaction are admissible. Dying declaration 26A, the statement made by a person who is going to die as to cause of his death, that is admissible. Statements of unavailable witnesses. Statements made by a person who is dead cannot be found or is incapable of giving evidence regarding relevant facts. So these are exceptions. Public records or documents. Official documents prepared by public officer in course of duty. So official documents which have been prepared by public officers in course of their duty can be admissible. So this is all about hearsay evidence and the principle on which non-admissibility of such evidence is based. Now coming to question number 5. Question number 5 is, who is an accomplice? हिंदी में कहते हैं इसको सह अपराधी कौन है? Who is an accomplice? Discuss the rules applicable to admissibility of the testimony of an accomplice. एक कौन सा नियम होगा, कौन सा रूल्स एप्लीकेबल है कि उसका जो है टेस्टिमनी, जो भी गवाह के रूप में सह अपराधी काम करेगा, वो एप्लीकेबल है या नहीं. सो आंसर विल बी एन accomplice इज ए पार्टनर एसोसिएट इन द कमीशन ऑफ ए क्राइम. वो क्या हुआ, जो भी अपराधी है उसका एक पार्टनर है इन द कमीशन ऑफ ए क्राइम. समवन हु knowingly participates, aids or abets the offense. Under Bhartiya Sakshya Adhiniyam 2023, specifically Section 138, an accomplice is considered a competent witness, meaning their testimony is admissible to convict an accused person. His testimony, जो भी वो गवाही देगा, is admissible to convict an accused person. Rules applicable to admissibility, BSA 2023, competent witness, Section 138. An accomplice is a competent witness, and a conviction is not illegal simply because it is based on their uncorroborated testimony. Now, rule of prudence or corroboration, Section 114, illustration B. Although legally competent, courts rarely convict solely on accomplice testimony. Whatever the accomplice says, courts rarely convict solely on accomplice testimony. It is a rule of prudence, a safety rule to require independent material corroboration corroboration to prove the testimony is credible. Nature of corroboration, pushchikaran. Corroboration must link the specific accused to the crime rather than just confirming that a crime happened. He has to prove that there was a crime. Exception: if an accomplice is granted a pardon in exchange for truthful testimony, he becomes a competent witness for the execution. So friends, this is all about the 5 most important questions of BSA, and what I hope that these questions are very important for you for the forthcoming examination, and you must memorize these questions, and these questions will be very helpful to you in your exam. Thanks for watching this video.